sticking with the budget topic, next is the public hearing on the fiscal 2017 school district budget, where members of the community are given the opportunity to address the board on budget-related matters. Anyone wish to speak on the budget? I am seeing no activity at all on the budget. Okay. So I'm going to assume we have one on the budget.
On the budget, yes.
Please come up to the dais. Yeah. This is the time.
Dan Charleston. Just a question on the ancillary revenues. You said that we're a revenue producer, and some of those funds are channeled back into the district. So I don't, what exactly are you referring to when it's channeled back into the district?
Ms. Juliana?
And how much exactly is that, those revenues?
So, in the community programs, for example, and in the rental of the Performing Arts Center, we have approximately, I'm going to say it's approximately $500,000 coming back in to offset the needs of the district and its expenditures. So about 500,000 has been the number each year that has come back to help cover the costs.
Okay, and is that broken down anywhere in the budget on a line item basis? Or?
There is a segment within the budget that identifies what that source of funds is, and looking through my charts here, but there is a line on the revenue list that identifies that.
Bernie, on your presentation, I believe there was a line in your PowerPoint, I think it was $622,000.
Just gotten to that page, yes. So you'll see that as a community programs transfer, and it is $662,000 for next year.
Thank you.
You're welcome.
Thank you. Anyone else on the budget? Okay. Now, before we get to the good of the cause, Mr. Jacoby, last meeting, members of the community had presented us with a draft resolution which we had asked you to take a look at regarding park testing. Did you, what's the status of that now? I know we circulated that among the board members here fairly recently. I want to just get an update on.
Yeah, I have I've reviewed it. I have actually made some modifications. There's been since the last board meeting, there was an interesting, a lawsuit. We were all provided copies of the lawsuit that the ACLU filed and the Education Law Center filed against the New Jersey Department of Education. And the lawsuit, I've reviewed that, and the judge actually made some preliminary comments at a hearing very recently after the last board meeting. And let me give you the premise of the lawsuit, and I'll just kind of tell you what what they're seeking in the lawsuit. So they've sued the Department of Education, and they're seeking a declaratory ruling that the new graduation requirements that were set forth in memorandums issued by the commissioner in September of 14, and then again in 15, failed to comply with the Graduation Standards Act, which is a state law. And it also failed to comply with the standards and assessment regulations, which are found in NJAC 6A8. And they've also indicated that the Commissioner of Education and the Department of Education failed to comply with what's known as the Administrative Procedures Act. It's somewhat similar to when we have a reading of a policy and then a second reading. Regulations can't just be summarily adopted. The Commissioner of Education can't summarily issue memorandums declaring things. And so what happened is in this lawsuit, they're seeking to stop the park testing as a graduation requirement for the failure to comply with the Graduation Standards Act and the Administrative Procedures Act, because it wasn't done with a public hearing, formal input, etc. What was interesting, and I think the resolutions that you guys were provided with at the last meeting didn't have the benefit of the judge's initial assessment. Now, he hasn't made a ruling, but that ruling is going to come out probably in due course. And I'll just read to you in the paper what the judge said, which this was just reported. Judge Thomas Betancourt said that what the officials did was inappropriate or improper, and that they frankly did not follow, they broke the law in deciding to use Park as a new high school exit exam. And I think the premise, and what I'd like to do is have your indulgences to get a copy of the judge's ruling. I actually know one of the attorneys that's handling it on behalf of the Education Law Center very well, and I've reached out to him to get a little bit more information on it. Because I think that what the resolutions said is they were basically mirroring what the lawsuit was seeking as a prayer for relief. And the resolutions that, so far, I think I've counted about 10 school districts have passed resolutions similar to this. The resolutions seek that the DOE, the New Jersey Department of Education, withdraw its pending graduation requirement proposals from the State Board of Education, that they follow the Governor's College and Career Readiness Task Force recommendations, that they urge the SBOE to take necessary steps to implement this recommendation, urge a multi-year transition, et cetera. I think what's missing from this resolution, which probably should also be contained in a resolution, would be what Judge Betancourt is citing to, which is requiring that the Department of Education and the State Board of Education follow the Administrative Procedures Act. If you're going to make a change, the whole purpose of this is that if you're going to make a new graduation requirement and make children, seniors, responsible for taking the Park test to graduate, there should have been input and a dialogue on it before that was implemented. And the ACLU and the lawsuit and the Education Law Center, there was one thing I wanted to read to you. I just thought it was interesting. Hold on. They said the new graduation requirements imposed, this is one of their causes of action, the new graduation requirements imposed by the DOE through the memoranda issued in 14 and 15 clearly constitute an agency action or determination that can only be implemented through publication, adoption, codification of regulations pursuant to the procedures under the Administrative Procedures Act and the Office of Administrative Law implementing regulations. So I think that what you saw with Judge Betancourt initially in his ruling, literally within the last week, was that he thinks they may have broken the law because they didn't follow the Administrative Procedures Act. So what I suggest that we do is take the resolution that's been adopted by East Windsor, Highland Park, and a few other districts. I think Princeton might have adopted one recently as well. I think Hopewell Valley did, is actually take this and then build in what Judge Betancourt's saying and stress the whole Administrative Procedures Act. Now, the one thing that people should understand is that, and this is in New Jersey, when you have an action against the Commissioner of Education, you file it with the Commissioner of Education. It gets transmitted to the Office of Administrative Law before an administrative law judge. The administrative law judge, in this case, is Judge Betancourt. Judge Betancourt will issue a ruling, and the ruling is a recommended ruling. They don't have buying authority. They issue a recommended ruling that then gets transmitted back to the administrative agency of the executive branch of government. So it will go back up to the commissioner, who has the ability to accept, reject, or modify that ruling. If, let's say, Judge Betancourt says you broke the law, as he seems to be indicating, it would go back up to Commissioner Hespy, who could either accept, reject, or modify that decision. If either party, and both parties have the ability to file what's known as exceptions with the Commissioner of Education. At that point, the next step in the procedure is it goes to the appellate division. And so very often, and if you recall, we had the similar case with the charter school many years ago, where we went to, we petitioned the commissioner. We said they didn't comply with the regulations, they didn't comply with the statutes. They denied us. We brought it to the appellate division, and then the appellate division said, we rely on the expertise of the state agency. The standard of review before the appellate division, they use a very heightened standard of review. The executive branch of government, they give great deference to the Commissioner of Education or the Department of Labor, and they say they have expertise in that area. And so unless the court finds that their actions were arbitrary, capricious, and unreasonable, they won't overturn it. If the Judge Betancourt rules that they violated the law, I think that that strengthens your resolution tremendously. And I also think that the resolution, if you're going to adopt a resolution such as this, you should really focus it on the Administrative Procedures Act, because the whole purpose of it, of the Administrative Procedures Act, is the public. Just like when you pass a policy or regulation, you give notice to the public, they can comment on it, you have experts. And what was really interesting in the lawsuit, which I wasn't following this when this initially happened, is that the Education Law Center and the ACLU went before the State Board of Education back in, I think, 13 and 14, demanding that they have the hearing, and they didn't have the hearing. So that's where it stands right now. So there's been about 10 schools that have passed these resolutions. They passed the resolutions before this has come to fruition with the judge. So I'll defer to you. It's really ultimately a board decision, but this is definitely a dynamic thing, and I think that there's they've got some really sharp attorneys on this lawsuit who've come up with very, very powerful arguments as to how to, go after this park assessment, making a graduation requirement.
All right, so if I understand, then you'll take pen to paper and we'll circulate something if you...
Yeah, I absolutely will. I will have it circulated shortly, but
Okay.
I have to, unfortunately, in the Office of Administrative Courts, they don't have stenographers. They tape it, so you have to order the tape and get it. I've reached out to the counsel that I'm friendly with who is involved in it, and I've asked him to see if he can provide me
Thank
with any information he has so that we can bolster the resolution for your guys' consideration.
All right, thank you.